And the man accused of shooting and killing Ahmaud Arbery, a 25-year-old black man who was out for a jog in Georgia last year, testified today that he was being attacked and didn't want to shoot Arbery.
I was thinking of my son.
What did you do?
I shot.
Why?
He had my gun. He struck me. It was obvious that he was attacking me, that if he would have got the shotgun from me, then it was this is a life or death situation. And I'm going to have to stop him from doing this, so I shot.
Travis McMichael, one of 3 accused killing Arbery, was the first witness to take the stand. Travis's father says they and a neighbor pursued Arbery, thinking he was responsible for a string of neighborhood burglaries. Well, Sacramento attorney Mark Reichel joins us now to discuss these high-profile trials. And as we mentioned, the jury in the Kyle Rittenhouse trial, they just finished 2 days of deliberations. Now, the longer this goes, is this a good thing or a bad thing for Rittenhouse?
You know, there's no real data. There's no real science whatsoever. There have been studies, and the studies show really that it comes out as a wash, whether or not the longer they deliberate, what that means for either side. What it really means is they're doing their job. They're taking their job very seriously, which includes maybe, you know, some argument and some discussion, heated discussion going on by maybe both sides in the case. But it never really, you can't correlate that to, wow, that's really good for the defense. Wow, that's really good for the prosecution. You just can't do that, especially this. This is several counts. There are 3, big counts, 3 shootings, and a lot of complexities. A defense that has a lot of complexity, it's very complex also with a lot of facts and weaving the law in. You're asking these jurors to become basically lawyers during the trial.
Yeah, no way to predict what will happen there. So, Mark, Kyle Rittenhouse and Travis McMichael both took the stand in their trials. How common is it for defendants to testify in their own defense in cases like these?
You know, it's actually rather uncommon, and here's why. The great thing about the defense is you don't have to put any evidence on at all. So the prosecution gives an opening, and then you get a close after you've attacked them. You've been going on the attack, and no one's perfect. The prosecution's case is going to chip away when you cross-examine it because no one's perfect. Then in closing, you get to say, look, they made you a promise. They didn't deliver. You can't convict on broken promises. So if you put the defendant on, however, 2 things happen. Everything you did positive before that goes away. All of that you did that scored the big points you goes away. And the second thing is, does the jury like the person? The jurors are humans. They want to do the right thing. And as a result, they're going to take a look at this person and determine whether or not they actually like the defendant. And that's going to be the determinative factor if you put your client on the stand. It's actually more rare than you would think. I've only maybe put 3 or 4 clients on in 30 years.
So do you think it was a mistake for them to put them on the stand?
To be honest, I think it shows that you have to, because it's a mathematical equation. You put on the table what hurts you, and you make sure you have over on one side what helps you. And at some point you realize, look, we got nothing left. It's like a 15-round prize fight, and you're down on the card 14 rounds. You got to go in there and knock them out, or you're going to go down on points.
Well, early on in the Rittenhouse trial, we watched the judge just tear into the prosecutor in the case, claiming that he was doing something that would possibly lead to a mistrial. The jurors watched all that happen. How do you think that's going to persuade the jury's decision?
You know, honestly, when closing arguments happen and they go into deliberate, what they've just heard is the closing arguments, and that's kind of where they focus. They do focus on facts, actually. And like I said, a lot of it goes on between the posturing and the drama that goes on between the parties isn't really something that they use. They are able to compartmentalize that. I talk to jurors after my trials, and they'll say, boy, the judge really seemed to be going at it with you, but we didn't give that any effect whatsoever. And that is true. So a lot of that really isn't going to stay once the doors close in the jury room. Those bags aren't coming into deliberations usually.
But could it be grounds for an appeal later?
Yes. So that's what's going on in the Rittenhouse case. Is saying, look, late in the game, we got some video. We thought that was not fair, but we went forward. Now the jury is really focusing on it. So that really magnifies our argument that we earlier made about a mistrial. So the judge is going to have to find out whether this was an intentional thing done by the prosecution or so reckless and also really, detrimental to the defense. If they can show this is really reckless and really detrimental, the judge may grant a mistrial, which doesn't mean the case is over. Usually mistrials mean we're just going to have another one. If they can show real extreme misconduct on the part of the prosecution that caused the mistrial, then the defense can say the U.S. Constitution You can't be twice put in jeopardy under the Fifth Amendment. We all know it as double jeopardy. You can't be put in that peril to go through this entire process twice, especially if the prosecution makes you go through it twice. So that's where the judge would have to get involved and take a look at all of those factors. If he is considering granting this mistrial, what will happen afterward?
All right, we'll see where it goes. Very interesting. Mark Reichel, thank you for your time.
My pleasure. Thank you.